4, UT System Board of Regents versus IDEXX.
May it please the court, Mr. Harris will present argument for the petitioner. Petitioner is reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The royalty question here is straightforward based on the contract's plain language, notwithstanding IDEXX's attempt to manufacture ambiguity. I'll address 3 points. First, there is no ambiguity in the royalty provision. Subsection 3 plainly covers the products at issue, and subsection 2 does not. Second, IDEXX's interpretation of the agreement is unreasonable. And third, the Court of Appeals erred in finding ambiguity. As a matter of law, only subsection 3 covers the products at issue here. The parties agree that these products fall under either subsection 2 or subsection 3. And those subsections are set out on tab 1 of the petitioner's oral argument exhibits. The products here are called SNAP products, which were a single-use veterinary testing device. As shown on tab 1, these products all test for Lyme disease plus 1 or more tick-borne diseases and heartworm. The 3 SNAP products therefore contain a total of 3 tests, 4 tests, and 6 tests. These SNAP products fall under the unambiguous language of subsection 3. That subsection applies to products sold to detect Lyme disease in combination with 1 or more tick-borne diseases. The SNAP products all do that. They test for Lyme disease plus 1 or more tick-borne diseases, so they fall squarely within subsection 3's plain text.
What would the royalty be on a product that detects Lyme disease in combination with 2 other veterinary diagnostic tests that are not for tick-borne diseases?
That is a non-existent product. That was a product that was never contemplated, proposed, or used. That product would not fall within the royalty provisions in section 5.1 because it's not a product the parties ever contemplated, ever talked about, ever proposed, and certainly never produced.
So if such a product had unexpectedly been produced, there would be 0 royalty, you think?
No, Your Honor. Section 4.1 of the agreement says that the license given is a royalty-bearing license. So there is a royalty that would need to be paid on any product. If IDEXX were to produce such a product, again, it wasn't contemplated, it wasn't produced here, it's a non-existent product, but if they were to produce it, they would then have to go back to the board under the agreement and determine what the royalty would be. Otherwise, they would be in breach of the agreement if they were to produce it without paying any royalty. So it wouldn't be free. It's not covered under these 3 provisions of 5.1 because the parties never contemplated that. And this license agreement was in place for 17 years. There's no evidence that at any time before or during anyone ever discussed, proposed, contemplated any such product. And in fact, we know now in reality no such product was ever produced. This is simply a product that we've heard about for the first time after this lawsuit was filed. It's a product that IDEXX has come up with.
No, I wasn't referring to a specific product. I'm just looking at the way you're interpreting these provisions. There seems to be a hole in your interpretation in which products like that would fit.
And the first time that product was ever raised, a product like that, was when this litigation started. And IDEXX came up with what they call a contemplated product. But again, it's a non-existent product that was never contemplated by the parties. There's no evidence in the record that it was. It simply doesn't fall within section 5.1.
And the 17 years that we referred to, I think for 13 of them, UT accepted 0.5% under paragraph 2. Was that just, as the record reflect, was that just an oversight? Was there an agreement of some implied agreement? Or what's the circumstance there?
UT was not aware that the royalty was being paid under the improper provision, being paid under 2 instead of 3.
Well, they certainly could have been in light of the amount being paid, right? Or could they not determine from the amount being paid that they were being paid 0.5 instead of 2.5?
There's evidence in the record, and again, this isn't, these are other issues that are remaining in the Court of Appeals.
I understand there's waiver issues on that, but I'm just curious because you said for 17 years and curious what the record reflects the circumstances.
The evidence from the board is that it did not realize the royalty was being paid under the wrong provision. The first time it realized that was when it exercised its audit rights under the agreement, which it has the right under the contract to do. It exercised its audit rights, had an auditor come in and look at it, and the auditor said, this is being paid under the wrong provision. Let's look at what the test is, look at the language. This should have been paid under subsection 3, not under subsection 2, and that's where this case began.
I want to understand, is the product that Justice Blacklock just described, is that what is contemplated in the NA box in the flowchart?
Yes, Your Honor.
And is that the only product that would fill the NA box?
I believe so, and that's what I was about to get to whenever I had another question. But yes, that is this non-existent product. It does not fall within 5.3. I believe that's the only product that it would be, because we have line only in subsection 1, which has the one test. Subsection 2, we have line plus one other non-tick-borne. And then in 3, we have line plus one or more tick-borne. So the only thing that wouldn't fall within those would be something that would be line and non-tick-borne, like subsection 2. But subsection 2 has that limit of one other and a limit of 2 tests. So that would be the only product that would fall outside.
Wouldn't Lyme and one tick-borne also fall under 2, under your reading? It sort of falls under 2 and 3, and then maybe it'd say 3 is more specific to tick-borne, so that controls, but...
Yes, Your Honor. Under the agreement, Lyme plus one tick-borne disease could arguably fall under 2 or 3, but that's why we have the canon of contract construction to look at the more specific controlling over the general. Subsection 3 talks about Lyme plus one or more tick-borne diseases. Subsection 2 says Lyme plus one other disease. The tick-borne is more specific, so therefore Lyme plus one tick-borne would fall under subsection 3 under that canon of construction. And that's just ordinary contract construction that allows that result. IDEXX wants to focus on subsection 2, but the SNAP products here can't fall under that subsection because it applies only to products with 2 tests. Subsection 2 covers products that detect Lyme disease in combination with one other test. The word one means exactly what it says, one. A product including a test for Lyme disease plus one other test must have its equivalent 2 tests. But the SNAP products here contain 3, 4, or 6 tests. By its plain text, the SNAP products can't fall under subsection 2. And other provisions of the agreement confirm that it doesn't mean one or more, or at least one, as IDEXX argues. Subsection 3 covers products that test for Lyme disease in combination with one or more tests for tick-borne disease. So we know that one doesn't mean one or more. And section 2.1 of the agreement uses the phrase at least one. So we know one doesn't mean at least one. And it's also important...
apart from evidence about the negotiation of this particular contract and what these parties were thinking, what would be, in terms of this industry and how this industry works, what would be a business justification for the higher royalty when you add a tick-borne test?
I think the royalties here do make sense. If you look at subsection 1, it's Lyme only. That's the highest royalty under 5.1 because Lyme is the driver of sales. Then you look at subsection 2, and you've got Lyme plus one non-tick-borne test. It was contemplated it might be heartworm, it might be something else. Heartworm was used as an example, but there the Lyme test can be no more than 50% because it's a 2-test product, and typically it was contemplated that it would be, for example, the heartworm test that would be the driver of sales in that, and Lyme is the one adding on, so it would have a lower royalty. It was simply to differentiate the existing non-tick-borne test. And then subsection 3 is the middle ground that we have Lyme plus multiple, one or more tick-borne tests. That with Lyme and the tick-borne, it's more likely that Lyme disease is going to be the driver of that. It may or may not have another non-tick-borne test, but it's typically going to be Lyme plus, here 1, 2, or 4. So if you look at these, for example, the tick-borne aspect must be at least 2/3 and could be 100% of the product. So it makes sense that that is the middle range royalty. So that's why these buckets make sense from a business standpoint.
Except I think what they would say is that under that explanation of the business, how the business looks at these things, the presence of the heartworm test is what makes the royalty, makes it make sense as a business matter for the royalty to be at the lowest. And so then you've got a heartworm test and a tick-borne test in the same product, and, where are you?
That's disputed evidence. That's parole evidence that shouldn't be coming in, and it is disputed. We have evidence that, in fact, the tick-borne, the heartworm test are becoming very stagnant in the market, and what they needed was something to differentiate, which they did with the Lyme disease. That's in their SEC filings, that after they brought the Lyme disease and added that to the heartworm test, the sales actually increased. So that's very disputed in the record. We dispute the parole evidence. But the important part here is, none of that matters. That's all parole evidence. It's the language of the contract. These are the categories that the parties decide on. And that's what we're asking the court to do, is to enforce the unambiguous language of the contracts.
When you say it's unambiguous, the point seems to be that it's unambiguous with respect to its application to the products at issue here, and that we shouldn't look to a non-existent product or some other application of the contract to determine whether there's an ambiguity. Why would that be under contract law?
Why wouldn't you look at the...
Why wouldn't we just look at the language itself and say, if there's a gap here, that gap creates an ambiguity, regardless of whether the facts, fit within the gap?
Well, it's perfectly reasonable to have a test that might not cover everything that could ever be done. That's for the parties to decide in drafting a contract. Otherwise, a party is going to have to gameplay every possible scenario that might be dreamt up, or someone is otherwise going to come in and invent something for litigation, find some gap that the parties didn't discuss, didn't need, and use that to argue that the contract's ambiguous, which is what has happened here. We have 3 categories of products that the parties decided royalties for. There's no indication the parties ever intended to have Lyme disease be added to multiple non-tick-borne tests. It just was never anything anyone thought about.
Your point is that the ambiguity has to relate to the adjudication of the dispute at hand. It can't be some other ambiguity in the contract that's not determinative of the outcome.
That's right, Your Honor. In cases from this court, like the Universal CIT credit, which is cited in our brief, whether a contract is ambiguous is applied to the subject matter of the suit. You look at what's in issue here. And again, in a case like this, there might be something that the parties decide, we're never going to deal with that. Why would the court want to force the parties to have to contract for every possible product, even if they're products they knew they were never going to create? Because we had talked about Lyme only. We've talked about, in subsection 3, Lyme and other tick-borne and maybe something else. And in subsection 2, the parties were real clear. All that we want to deal with is Lyme plus one other test. Why should the court make the parties say, no, you didn't contract for Lyme plus multiple non-tick-borne tests, therefore we can't read these provisions 1, 2, and 3. We can't read those and interpret them.
I'd understood you to say that the parties did in fact contract for that underlap by saying, if something else comes out, 4.1 says we're going to talk about it then and reach a deal on the percentage then.
Yes, right. It would be covered. It would be picked up under the agreement because it's a royalty-bearing license. So any use of the product, any use of the patent has to pay a royalty. And so if the parties later decided, if IDEXX decided later it wanted to have Lyme disease plus multiple non-tick-borne, then you go back under the contract and it has to come up with what the royalty is. The parties have to agree. If the parties don't agree, and IDEXX produces it without paying a royalty on it, they would be an infringement of the contract. And so it does. And again, looking at the flow chart, we account for that. It's not ambiguous. Just because there's a product that the parties didn't put under the royalty provision doesn't make it ambiguous. It's perfectly accounted for in the language, and all of these subsections make perfect sense.
On the topic of what we can and cannot properly consider when we're trying to construe this language, is there a difference between evidence about past conduct or about the way the contract was negotiated, which is sort of classic parallel evidence on the one hand, and then on the other hand, can we consider perhaps outside sources or perhaps the parties' statements or agreements about the nature of this industry and the sort of business purposes for which an agreement like this might have been entered into to help us understand the industry so that we can interpret the contract in light of its business purposes? Is the latter permissible?
Your Honor, that would be parole evidence, and that's not the type of surrounding circumstances that would apply here. Let me look at both of those. Whenever they are wanting to look at other conduct here, what they're wanting to look at is negotiation history about what the parties negotiated. And there were depositions taken of what happened almost 20 years prior. I mean, this contract was signed about 23 years ago now. And some of the depositions testimony is, I don't remember. And that's why we don't have parole evidence to be coming in. It's the language in the agreement that controls, and the party's intent as expressed in the language. This court has said it doesn't matter what the party's intent is. It's what the party's intent is that is expressed in the language of the contract. And the parties have a duty to put their intent in those words in the contract. So looking at what the industry might think about this would be parole evidence. And then looking here at surrounding circumstances, which is what IDEXX tries to argue, and that's a backdoor way to try to get into parole evidence. They're arguing surrounding circumstances, but if you look at, for example, on page 59 of their brief, this is one point where it's clear. This is really just negotiation history. Surrounding circumstances is used to explain the meaning of the words the parties used. Here, those words are clear. There are no terms of art. We have the word one, we have non-tick-borne, we have test. We don't need surrounding circumstances to know what those words mean. Those words are clear, and the court should not use surrounding circumstances to create an ambiguity in an otherwise unambiguous contract.
Can I just ask one confirmation? The system did not sue for past royalties on any product that only tested for Lyme and one disease.
Your Honor, there were a total of 4 products produced here. The 3 SNAP products at issue, which were the bulk of it, and if you look at it in total, it was $900 million in sales of those 3 products. These were big products. The only other product was a Lyme-only test, which was paid under 4. So
we're not seeking royalties for past sales of any product that tested for Lyme and one other disease.
Correct. The only products that we are seeking are the 3 products set out on tab 1, the 3 SNAP products. Those are the only products at issue here in the royalty provision.
Any other questions? Thank you, Mr. Harris. We'll hear from the respondent.
May it please the court, Ms. Hobbs will present argument for the respondent.
Chief Justice, and may it please the court. I want to jump right into what makes this contract ambiguous as applied to the SNAP products that are issued now. I like to think of Section 5.1b as buckets, and so we all understand Bucket 1. Bucket 1 is not an issue in this case, and we're having difficulty with what does Bucket 2 mean, what does Bucket 3 mean. And the reality is that the SNAP products at issue in this case can fall under either Bucket 2 or Bucket 3.
Doesn't your interpretation make the language one other mean the same thing as one or more?
I don't think so. And let me explain how I see the buckets and why I think that's a reasonable interpretation, and then I want to go address that question exactly after I lay it out predicate. First of all, I like to think of it, if there were no subsection 3, there were no bucket 3, no one would dispute that all the SNAP products detect Lyme disease in combination with one other veterinary diagnostic test. A plain reading of that, it would fall into that bucket. On the same hand, at the same time, if there were no 2 and you just had a 3, no one would dispute that the SNAP products detect Lyme disease in combination with one or more veterinarian diagnostic programs or services to detect tick-borne disease. These are combination tests. They could fall in either bucket 2 or bucket 3, and that's precisely why it's ambiguous.
Are you saying the tick-borne disease tests are not veterinary diagnostic tests or services?
No, I'm saying that it would still fall into 2 because it is Lyme disease. If you look at, I actually like their chart best, to be honest with you. It is Lyme disease, and it also is in combination with one or more tests, a tick-borne test. So it falls under that too.
I look at this and it's like an LSAT question or an English, a high school English exam question, right? And if it were that, and you describe these products in the question, and then the student chooses A, B, or C, which of these describes the products? These words, one other, if we're looking at it like an exam, make B the wrong answer, just as a matter of basic English. And if you had an exam question like that, I think everybody would agree that B is the wrong answer as describing as applied to these products.
When I taught at UT Law School, I let the students tell me when I don't like any of these answers, and here's why, and I could give them credit for that. And I think that's the actual answer here.
And I appreciate the way you opened your argument by highlighting, look, if there was nothing here but paragraph 2, then all these products would fit into it because all the products detect Lyme disease and one other veterinary test. I get that. But there is more there than paragraph 2. There's paragraph 2 and paragraph 3. And don't we have to read the two together to figure out? Because if paragraph 2 means what you say it means in your opening, if it was standing there alone, it's plain on its face, means this. If that's what it means, then paragraph 3 is completely superfluous. Right? So we have to read the two together, and once you do that, it seems to me you lose any of that ambiguity.
I disagree that we lose the ambiguity, but I want to highlight one issue with both of them here, and I think Judge Lerman, this goes to your question as well, is all of these tests, like as long as one other means one other non-tick-borne test, which Mr. Harris did tell you that in his opening. I wasn't sure if that was his position, but he did admit to that. Then the SNAP products, they all do have one other non-tick test.
But if that's all that paragraph 2 means, then doesn't paragraph 3 become completely superfluous? If we read 2 the way you're wanting us to read it in order to create an ambiguity, then doesn't 3 under that reading of 2 become completely superfluous?
I believe that I do not have a perfect argument, nor does the other side have a perfect argument. That's precisely why this contract is ambiguous.
And that would be perfect. This has to be reasonable.
It
seems to me yours isn't reasonable because it requires us to read 2 in a way that renders 3 superfluous.
I don't think so, and I think I can also say the reverse, and let me explain. First of all, I do believe you have to read this in the context of setting reasonable royalty rates. So it is equally unreasonable to imagine why the board would agree to accept a lower royalty rate when the Lyme test is one of only 2 tests. And then equally true is why would IDEXX agree to pay the board a higher royalty rate when the board's Lyme test is, one of multiple tests? So there's problems with their argument too, and that's what the court has to hold. It has to hold that theirs is the only reasonable interpretation of this contract.
Is that latter argument essentially an absurdity argument?
I don't like to use that word because I don't think you like to use that word, Judge, but
But if I liked it, you would like it instead?
I might have said it when I was practicing and then took it out of my... No, it's not really absurdity. It's really just, they want to read these provisions of 5.1b out of context. And you have to look at the context of setting royalty rates and why are people setting these specific royalty rates.
But does that not at least lead to the question of whether or not there were particular kinds of products in mind? That is why your friend on the other side was commenting we didn't cover the potential waterfront of the universe because we had certain things in mind. And so then for courts to come in and say, well, why would they expect more royalty for something which is a smaller, like there are all sorts of business considerations involved that seem to go way beyond our scope if the language itself, when we have a relatively short provision that uses one other and then one or more, seem like the parties specifically chose different language to convey an unambiguous meaning. And if the only way to get past that is for us to think, well, that doesn't make business sense, that's troubling to me, unless it literally is absurd.
It doesn't make business sense, I agree with that, but it ignores the fact that our tests, like these SNAP products, they all test for Lyme disease and one other non-tick-borne test.
Does the patented technology provide assistance solely for the detection of Lyme disease, which is a tick-borne disease, or is the use of that technology applicable to the detection of other tick-borne diseases?
There are other tick-borne diseases that are not Lyme.
Right, and what I'm saying is does what is provided by the patent, what technology is provided through the license, does that assist not just with the detection of one tick-borne disease like Lyme disease, but additional tick-borne diseases, which would be a justification for a higher royalty in connection with additional tick-borne diseases? In other words, does it provide some kind of a platform or ability to test for other tick-borne diseases?
It does, but not that the board is concerned about. The board's tick-borne test is only Lyme disease. So if they only contribute to the Lyme disease test, that is reflected in these three-tiered royalty rates.
But would your product detects, say 3 tick-borne diseases, if one of those diseases was not Lyme disease, would your product have the same market value that it would have, given that Lyme disease is the one disease that everyone is concerned about because it's transmissible to humans?
I don't want to go too far down this because I'm really trying to avoid going into parole evidence at all. But the circumstances are, one thing I think this court has to understand to make sense of 5.1, and I think is objective information that absolutely this court can look at when analyzing this, is that Lyme disease is not deadly in dogs. Heartworm disease is deadly in dogs. So heartworm disease is a non-board patent that is driving the sales. Your veterinarian wants to test your dog every year for heartworm. Most dogs are asymptomatic on Lyme disease. And so that is why, to understand...
Lyme disease is a pretty significant concern.
It is in humans.
For people.
It is in humans, but in dogs it's not. And I don't know, and I apologize that I don't know this, but I don't know that there's anything in this record that says a dog having Lyme disease could transfer that to a human. I believe it is not in the record, but if I'm wrong on that...
No, the tick.
The tick, yeah.
The tick from the dog.
The tick from the dog would, but the Lyme disease... Yes.
So
but that's unrelated to these products.
So if a product detected Lyme disease and one other tick-borne disease, would any royalty apply?
A Lyme plus one other tick-borne, it would fall into 3.
So you are conceding that it would be under 3?
Yes.
If you're right that one other test also means at least one other test in subsection 2, then why wouldn't we look at
that is sort of the general category, and then the 3 is about the specific case of tick-borne tests. And so 3 controls, tick-borne tests are a subset of what 2 is talking about, and so when you have the special case of tick-borne tests, you have 3.
That is precisely how these parties viewed this contract for its 14 to 17-year event, is exactly what you're saying. And so...
Well, no, but what I'm saying is that any tick-borne test in the product gets you to 3. Because 3 is about the special case of products that include tick-borne diseases, even if number 2 includes multiple tests. One other can mean at least one other, so you can have multiple non-tick-borne tests that fall under 2.
Right.
It looks to me like 3 is a sort of a more specific provision about a subset of what 2 is talking about. And if there's a tick-borne test, then you're under 3.
I think that is the board's position, that
Right.
that would fall under 2 because it's...
Why is that wrong as a way of looking at 2 is the general case, 3 is the specific case about tick-borne, and so here we are with a tick-borne test, and it's
We're talking about hypothetical tests that they don't want us to talk about, but under that hypothetical test, that is not a SNAP product that we're disputing here today. But in that hypothetical test, then, that is their position, that it would fall under 2, but it would also be a disease that would be the one test that pushes that to 3, where you have that ambiguity is 1 or more. They both 2 and 3 contain the word 1. That's why that is ambiguous, and that's why they say it would fall into 3. But that test is not one of the SNAP products. There is no SNAP product that is Lyme plus 1 other tick-borne. They all have heartworm in them.
right. I think we're missing each other talking about different things. Yeah. So let's assume I agree with you that in subsection 2, 1 other veterinary diagnostic test could also mean 1 or more. So I agree with you on that. Are tick-borne diseases veterinary diagnostic tests, such that tick-borne diseases are covered by the general category of 2? And then if you look at it that way, why isn't 3 just a specific rule for any product that includes a tick-borne test as kind of a subset of the general rule in 2, and then you would apply the more specific rule in 3 to anything that has a tick-borne test in it, including the products that are at issue here?
And I think that, so our interpretation, I'm sorry if I'm misreading what you're trying to say, but I think both parties say, number 2, when it says 1 other, they mean 1 other non-tick-borne disease. I think both parties would agree with that. So the only ambiguity is a product that doesn't exist. It is ambiguous, but the only way they are seeing an ambiguity is what you're proposing, which is Lyme plus 1 other tick-borne.
Well, here's what I think of it.
Okay.
We're going to give you a tax refund if you have 1 son and 1 other child. We're going to give you a bigger tax refund if you have 1 son and 1 or more daughters. You get the bigger one or the smaller one. And so you got a son and a daughter, maybe you have more than 1 daughter, but you have a son and a daughter, you automatically go to the bigger tax refund because you've got a daughter. That's how they're interpreting it. You got a Lyme disease test in each case, the son. And if you got the Lyme disease and 1 other test, a son and 1 child, you get the smaller tax refund. If you've got the son and 1 or more daughters, then you automatically go to in this case, paragraph 3. Why isn't that the...
It does not make any economic sense in the contract as the party, in the tiers that the parties are creating in this to say that. I understand your hypothetical, but when you're looking, if you construe 5.1b as a whole, which I think is what you intend to do if you go back and write this opinion, then it doesn't make any sense of why we're paying these various royalty rates under that example. The focus, the razor focus on this word 1 other or only 1 or more, that's interesting and it's simple. They want it to be math. But what it does is it ignores those royalty rates. And why do they have royalty rates? And you don't have to understand anything about the veterinarian industry even. Like from the structure of this, the structure is telling you what is the market driver. The market driver is heartworm, and we know that because they're getting a 1% rate when it has heartworm, because that's the driver of the sales. And they're getting, they would not agree, IDEXX would not agree to pay them more when it's our heartworm that is driving the sales there.
Maybe a better way to get at the question that we were discussing would be to ask, are veterinary diagnostic products or services to detect tick-borne diseases a subcategory of veterinary diagnostic tests or services?
They are both veterinary diagnostic services, tests or services.
Right. Okay.
They all are.
Okay.
That's why it's ambiguous, because it really can fit into 2 and it can fit into 3.
Well, but if that's right, then these tests that are at issue have more than one veterinary diagnostic test or service in addition to Lyme disease.
Yes.
And because the others are tick, I'm not hearing an answer to the point that 2 is sort of the general case, the general category of veterinary diagnostic tests or services, and 3 is specific to tests that have one or more tick-borne tests.
I think the general and specific is a red herring. They're meant to do with different categories. 3 really is meant to be tick-borne, right? We've never paid under 3, to be honest with you, because every one of the snack products includes heartworm. Every one of them does. That's why we've always paid it under 2. Because
everyone also includes tick-borne?
I'm sorry?
Everyone also includes tick-borne?
Right, but it's not a tick panel. So 3 would be a tick panel.
You read the provision and you think, well, clearly in this industry, tick-borne diseases are a big deal. And then your position is, no, it's heartworm that's a big deal, but the contract doesn't say that.
And I think
it doesn't reflect that.
It does in the royalty rates. That's why, because heartworm is our test, we're going to pay them less when our test is the driver.
I get it. It's hard to glean that from the language. Is all I'm saying.
Well, and just to answer the question of what is in the record that I think this court can look at as far as what's parole evidence versus surrounding circumstances is there are publications from independent third parties. These are at CR2, 1210 to 1212. And what this shows, and I think this is the only thing you need to know to really understand why their interpretation cannot be the only reasonable interpretation of this contract, is those objective facts. They are objective, they are not subjective, they are not disputed. Heartworm is fatal in dogs, so regular testing is essential. And Lyme disease is generally asymptomatic in dogs, so testing is less important. And I think it's shown in the structure of the 3-tiered system, so I don't think you have to go there, but it's certainly just taking that baby step to understanding this industry makes this clear what the parties were intending. It definitely undercuts their argument that their opinion is the only reasonable interpretation of the contract.
Would it be proper for us to have a holding that says that if we can confirm objectively that a business agreement doesn't make economic sense from both sides, that ambiguity?
Do you want to answer the question? I'm not sure I understood it though.
Well, I'm wondering how much work this doesn't make economic sense is really doing in terms of being the lever for a finding of ambiguity.
I don't think it's essential. I think it is why I do believe our interpretation is reasonable, but I think I'm going to go back to my opening is that these tests really keep the ambiguity in these SNAP products is they really can fit in bucket 2 and they can't
just
fit
linguistically.
Linguistically.
You'll rely on that.
Yes.
Any other questions?
One very quick thing. One structural difference between 2 and 3 is that 3 has seemingly an additional qualifier. 2 says licensed products sold to detect, and 3 says licensed products sold as a product or service to detect. I'm wondering, you don't think that extra phrase is doing any work, it doesn't have any part of your work.
I don't think it's doing any work, and I will tell you that if their numbers is right, 2 means 1 plus 1, and that's it, and 3 means 1 plus 1 plus 1 plus 1 plus 1, then why would we describe what kinds of tests they are at all? It doesn't make any sense. All this language is extraneous. You wouldn't need to define what kind of test it was, whether it's tick-borne or mosquito-borne, if they're right that this is some mathematical formula that once you hit 1 plus 1, it's out of 2 and into 3. It would not make any sense to have all the rest of that language. Thank you, Your Honor.
Any questions? Thank you, Ms. Hobbs. Mr. Harris, you have 5 minutes.
We've heard a lot about heartworm being the driver. If the court will look at page 30 of our brief, there's disputed evidence in the record on that. You look at the SEC filings, it shows that Lyme disease was in fact the key driver, that heartworm was a test that was becoming kind of very typical in the market, that it needed something to differentiate, and whenever they added Lyme disease to it, then sales took off. The Snap 3DX product made their cells shoot up. That's all in their SEC filings. There are pages of evidence that we cite in our brief on that, beginning at page 30. But again, none of that matters because that's not in the language of the contract here, and the court should look at the language of the contract. We also heard from IDEXX that subsection 3 is meant to be tick, and that it talks about a tick panel. Well, the word tick panel is not in here. There's disputed evidence in the record about what a tick panel is, and there is some evidence in the record that a tick panel means tick only, not anything else, but the parties didn't use that word tick panel. If they had, we might be up here looking at surrounding circumstances, what happens in the industry and the like, but we're not doing that because that word isn't here. And if the court will look at tab 3 of our bench book, this is taken from IDEXX's brief at page 31. They show that their interpretation has to change the words of the agreement. In subsection 2, IDEXX eliminates the one other test limitation by adding other words. They add, regardless of whether the licensed product also detects an additional disease or diseases. So it's no longer Lyme plus one other. It's Lyme plus one other, regardless of whatever else you may have. That's changing the language. And on subsection 3, IDEXX adds a limitation that it can only be tick-borne when that language is not in the agreement by adding and nothing else. There's no limitation like that in subsection 3. It is simply Lyme plus one or more tests to detect tick-borne disease. Period. That's where it stops. It doesn't say and nothing else. There's nothing in here that says it's meant to be tick. That's all parole evidence that this court should not consider. The language as written is unambiguous, and this court should enforce the party's unambiguous contract. This court should reverse the judgment of the Court of Appeals and remand to that court to consider the 2 issues that the court opposed in otherwise.
Any other questions? Thank you, Mr. Harris. The case is submitted. The court will take a brief recess.